Hi, my name is Sunny Sion Kang, and I'm the Senior Product and Privacy Counsel at Eightfold. I am a lawyer and an advocate who is interested in navigating the role of law and technology in supporting sustainable innovation. Artificial intelligence, or AI, is a really complex topic for policy and corporate governance, but I want to help dissect it by breaking it down into how the legislative framework on AI regulation is structured and how the policy principles around accountability support and underpin these emerging regulations on AI. After this context has been set, we will discuss how AI tools in hiring can fit into existing anti discrimination laws in the United States. When contemplating the use of AI in a sector that impacts livelihoods and opportunities, we should always be asking how automation will conform to well established legal principles of professional ethics, constitutional law, open and transparent processes, and anti discrimination. AI is a new entrant to employment, but it definitely doesn't supersede established legal doctrine on equal opportunity. So we should understand how the technology works, its nuances, and make sure that it can be deployed in a human centric way that respects legal principles that would apply equally to a human recruiter or human practitioner. In media, we often see depictions of AI in a very dystopian setting. The conversation disproportionately fixates on attention grabbing topics such as will AI replace humans in the workforce and out of control robots. But in reality, responsible AI strives to inform rather than to replace human judgment, and it is very ubiquitous already in our everyday lives. With the appropriate safeguards, big data can be both necessary and beneficial as a yardstick for informed decisions. For example, the government has a lot of demands on information processing that is very difficult to fulfill given their constrained resources. As the demands of modern governance increase, so does the need for emerging technologies to assist. And there is just so much information to process, and machine learning and AI can be an excellent tool in parsing out repetitive tasks and doing large scale analysis that would be very difficult for a human to do by themselves. There's various modes of machine learning and AI that are already being implemented or in the planning processes for government use, such as public administrative agencies. For example, AI is becoming more pervasive in monitoring compliance with tax and customs regulations, deploying natural language processing to understand common threads of consumer complaints and fraud, enabling network analysis for anti money laundering and to enable financial intelligence sharing across different money laundering consortiums, and detecting and combating market collusion. It's the same growth for the private sector, and there's many good uses of AI for many different sectors, such as diagnostic AI for medical innovation, and also human resources AI to help mitigate selection bias and to promote diversity. So before we talk about how AI regulations apply to these different industries, let's first go through what is artificial intelligence. Just as the law crosses over many disciplines into philosophy, economics, and history, AI is similarly dynamic as an evolving discipline. It also crosses over into mathematics, linguistics, neuroscience, and now increasingly employment law as well. So, even though AI often seems like it's a future problem that seems out of reach, it actually has a very long history dating from the 1950s, and it's been embodied in many forms since then. In essence, AI is broadly defined as the science and engineering of information that can simulate some human-like intelligence. And this intelligence can be embodied in many different forms, such as the physical forms, like internet-connected devices and robots, even your Alexa or your Amazon button that knows when you're out of air filters has some sort of artificial intelligence embedded in it. Or, more relevant to our conversation today, AI can be non-tangible in software, and it can be applied to cognitive functions and tasks such as predicting, planning, understanding, reasoning, decision making, and language processing. So essentially, it's information processing. It also crosses over into many different disciplines, like we mentioned. So conversations around AI began to take shape in Dartmouth in the 1950s with John McCartney's research group, who shifted focus from more analog machines into intelligent systems that can simulate human intelligence for abstract tasks. And now in 2021, there's many different definitions of AI by private sector and regulators all across the world. And this sort of disparity in definition exists because there's so many different scales and research paradigms on AI that go from simple causal relationships and binary decisions to more complex neural nets that become a lot more convoluted. But the ethical question is the same for all sorts of AI. Data powers AI. Information trains AI. It sets the goals and limitations for how much influence AI can have over our lives. And sometimes information is a mirror of societal prejudices. It has the potential to replicate biases that exist simply because a protected class can be overrepresented in a punitive data set that might make the AI think that they're more risky or inherently dangerous. Or if protected classes are underrepresented in a positive data set that excludes them from opportunities. So there's different types of AI with varying degrees of human control and contribution. And keeping in mind, our topic of AI today is applied to decision making, for example, in employment. These techniques and understanding them make a difference on accuracy, auditability, and explainability. There's supervised artificial intelligence, and supervised AI automates predetermined guidelines. Humans label the data, and there's some auditable logical regression from the input to the output of the system. AI would recognize patterns based on the labeled data provided by the human, who would also have a big role in overseeing and correcting the errors as well. It's a very deterministic process in supervised AI. It's a combination of if dot dot dot, then dot dot dot. That is sort of the algorithm that goes into it. And there's many different examples of supervised AI, which is image classification. If it's round and fuzzy, it could be a cat. Decision trees, price setting, and etc. But the simplicity sometimes has a drawback. Sometimes AI that is used in employment use a very simple keyword query on the resumes they receive in their ATS systems, which may filter out applicants without any context on why the keyword is there or the significance of it or why it's not there, or they may have related skills that relate to the keyword they're looking for, but the keyword itself isn't present. There's also unsupervised learning in AI, and unsupervised techniques feed the system with unlabeled data, and it allows it to find patterns without a predetermined set of rules. It works across immense data sets to extract meaning. It can imbue sentiment analysis into language, and it can help navigate new social contexts. There is also natural language processing as an example of unsupervised AI. It learns from different environments and understands cultural and social cues. For example, a tweet from Twitter might be very difficult to understand for someone who doesn't have the context around it. But this is where you have to be aware of bias creeping in. For example, a very scary example of unsupervised AI is in credit scoring. So outside of the hard factors, such as someone's credit utilization history, loan history, repayment history, financial institutions in the past have gotten into trouble with regulators because they began making adverse decisions on individuals based on neural nets trained on very skewed data that discriminated against women. So this kind of pretends my next topic, but how does information work in AI and why does privacy matter in AI? It is critical for institutions to be able to put a use to their data, especially when manual processes would mean missed opportunities, human error, and just lost opportunities that could have furthered the human condition if some automation had assisted the human in making those decisions and analytics. However, AI bias is an information problem. AI is only as good as the data you put in it, which is why it is deeply connected to privacy legislation, which discusses fair information practices and informational self-determination, which respects the dignity of data subjects and how their information might be put into an automated system and how their rights can still be respected with these emerging technologies. Regulators are aware of this, and they have been attempting to strike the right balance. Let's take, for example, the GDPR. The evolution of AI governance in the European Union actually has decades-long history. It began not only with the GDPR, but its predecessor, the Data Protection Directive of 1995. This directive in 1995 created a right not to be subject to automated decisions produced by computerized systems without human intervention. And it marked the inception of binding EU legislation on automated systems that threatened individual rights and had a significant or legal impact on individuals. And the policy rationale of this directive was to preserve human dignity and agency against the advancement of machine-led evaluations of personal data. But as the law matured and eventually the GDPR came into force, superseding the directive, it became more innovation-friendly. It began to balance the interests of innovation with the appropriate safeguards needed for individual privacy and AI ethics. Instead of strictly restricting the uptake of AI that can accelerate the digital marketplace and lead to a lot of opportunities and innovation and trade, the GDPR was designed to modernize AI regulation and make it workable for companies that were starting to offer services based on AI. EU legislative institutions were cognizant of the growing impact of AI on fundamental rights, but also how prevalent it was in completing everyday tasks. So there's a lot of difficulty for humans to manually process large volumes of data with accuracy and with speed. So GDPR governs AI by adding safeguards to profiling and encouraging human-centered AI. GDPR pushes forward greater algorithmic accountability from its predecessor directive in two ways: by reinforcing the right to an explanation and by instituting the right to obtain human intervention and to contest fully automated decisions. So if your system is fully automated and it automatically renders a decision on a real person without human review, this is a scenario that would come under the most scrutiny. A solely automated system always requires additional checks because it simply carries with it too many risks. So it would require context of justifying that the function it provides is so highly repetitive and quantifiable as a routine task that there's no room for discretionary judgment to be made solely by an AI system. And you would have to prove that you have a basis to use it under the GDPR, such as a necessity to perform a contract or a member state law that authorizes the use of a solely automated system and builds safeguards around it, or that you have consent that is necessary. Individuals should always have the right to be informed of being subject to algorithmic decision tools, because this is the cornerstone of algorithmic transparency. The privacy legislation focuses on the right of access to the input data and asking for an explanation of how your information could have factored into the decision and what variables may have been used. Under the GDPR, various articles, such as Article 15 and 22, gives individuals the right of access to information about an AI system. And this right includes access to meaningful information about the logic involved in the system, as well as the significance of the decision that it might make and the envisaged consequences of such processing on fundamental rights. And this is because without telling people that an AI system may be potentially evaluating them and giving them a logic about how it might be performing those evaluations, there would be no due process. Lack of transparency would lead to individuals having difficulty understanding if they've experienced adverse impact, if they have been discriminated against in some way. And without understanding anything that goes into the AI or the logic that it applies, it would be almost impossible for consumers with less than normal technical knowledge to understand how to demonstrate that someone has configured the system with discriminatory intent and knowledge, especially in order to file a discriminatory employment action claim against them. So let's apply this framework of AI ethics into the human resources context in AI for hiring decisions. The relevant federal law for employment discrimination in the United States is Title VII of the Civil Rights Act of 1964. Title VII provides judicial relief for job applicants who can prove that a prospective employer discriminated against them on the basis of a protected class, such as race, color, religion, sex, or national origin. Under Title VII, discrimination occurs when a hiring decision exhibits a legally unjustified preference that disadvantages an individual or a class of individuals based on their protected characteristics. Employers found to have engaged in disparate impact or disparate treatment will be found liable under this act. And victims of AI discrimination will likely have to find recourse under Title VII. So this is a very interesting way that new emerging technologies still apply to the same legal doctrine that have existed for decades, but the context in which someone might experience discrimination under AI systems might be different and have different ways to prove it as well. Disparate treatment is a discrimination that shows some sort of intentional design to discriminate, and it focuses on the element of human bias. Because AI systems by themselves do not have moral agency or some personhood in law that enables them to make legally significant actions, it's really not disparate treatment that most employers would be concerned about. It would be disparate impact under Title VII. Disparate impact is discrimination that may have been unintentional, but still had some adverse impact on a group of individuals that have a protected class. They also represent policies and practices that seem facially neutral, but have a disproportionately adverse impact on protected classes. It is not concerned with motive or intent, which is what makes it a very relevant topic in AI. The touchstone of AI big data and disparate impact is, are you excluding individuals on factors that have nothing to do with future job performance? Are you coding in a way that your model is focusing on factors that have nothing to do with job performance? For example, certain aptitude tests have been designed in a way that benefits white test takers of a certain cultural background and privilege. And this has been shown to have some disparate impact, especially in college entrance exams. If these aptitude tests have disparate impact, then it's likely that whatever cutoff score the employer chose as a threshold to be considered for an interview may have no relation with the individual's ability to do the work, and you may have no defense under the doctrine of business necessity. So, how can AI be used for good in this instance? How can we use AI so that we can look at historical data that may reveal what does or does not have to do with job performance? AI's beauty is that it can take an amorphous problem and hard code it into some quantifiable sets of variables and desired outcomes. AI has the ability to discern qualitative and quantitative characteristics about an individual through the data that we are analyzing and aggregating. And there's two components of AI. There is target variables, which set a desired outcome, such as finding an applicant that has the most optimal job-related skills, and class labels, which measure the degree of success that you are achieving target variables. And it's really important to note that target variables must be job related to comply with Title VII. And it's really important to also note that the target variables should be creating a model that is predictive of a job related trait and not anything else. Setting a target variable can lead to biases, and you need to be cognizant of these limitations and these potential for bias when you're coding it up. So setting a target variable that may be typically absent in protected groups may marginalize these groups in the resulting model. For example, if you are putting a lot of emphasis on the loyalty shown by a candidate on how long they stayed at their previous company, this may disadvantage women who are more likely to leave the workforce temporarily due to childcare, or people of color who may simply not have been given opportunities to move up and had to move companies to find a better career path. Conversely, overrepresentation of a group can also inflate its positive attributes in a model that makes them seem more qualified than other marginalized groups. So data mining from prejudiced decisions in the past can systematically infer and hard-code prejudiced rules. That is why it is imperative to oversee the quantity, quality, and the relevance of the data that you will choose as input for algorithms. Oversight of the data input for algorithmic decision tools is fundamental to identifying bias and inaccuracy to avert unfair outcomes. Because the specific consideration of protected categories and their proxies can create unequal distributions of risks across different groups, and it can also perpetuate categorically different treatment of groups, and it can replicate social biases and marginalized groups having to deal with stereotypes that have been embedded into the machine. This is why human-centric AI is so important. It is really important for any AI to have a significant human control and influence over it. A human should be able to overrule its suggestions based on a justification they can make that correlates to justice or that correlates to some information that the AI might not have. It is really important to establish checkpoints for transparency and accuracy at each processing stage and the design of the algorithm to improve data governance data quality, and also present the opportunity to correct hidden bias. So, as we move into a future where these tools become more powerful and more common, let's ensure that algorithms aren't configured with biased, inaccurate, or discriminatory training data, or are operating on criteria that may produce detrimental effects on individuals and marginalized groups. And that requires a privacy centric approach where you are creating accurate and complete data sets that represent a cross section of the population, and that you're not building a black box whose predictions are hard to audit. It's really critical that AI incorporate democratic values and respect for fundamental rights and anti discrimination principles as well. Thank you very much for listening to my presentation today.